So what we're looking at today is this COVID-19 that has come up and has sort of changed our lives at the moment. So today's agenda, I'm going to be looking at NEC contract and how that deals with the issues with coronavirus. Also, I'm going to touch on JCT, albeit that I appreciate that most of you don't do a huge amount of work on JCT. We're going to look at steps to take now, particularly relevant with NEC because, of course, it's very much a management contract. But of course, JCT's going a similar way, and also things to consider generally. Before we get into that, I'd just like to put all of this in context, because, you know, at the end of the day, we are in a pandemic, and I think probably none of us would have ever imagined that in our lifetime we would be in a pandemic. So, you know, issues of safety and reputation of the business are absolutely critical. And, you know, I know in construction, you know, safety is top priority. You know, I often say to my team when we're talking about contracts and disputes that, you know, actually, you know, that's really important to us, but actually to you guys, top of the list is safety of your people on site. So safety and reputation are really, really important. But what we're looking at today is the financial side of things. So the time, because of course time's money, and also getting extensions of time to avoid liquidated damages. Just before we start looking at the financial issues, I'd just like to touch on the safety and reputation. It's not my area at all, but what I would say as a sort of risk mitigation issue is follow the guidelines that we're being issued with. I know it's all a little bit confusing at the moment, and I'll come back to that. Keep track of the guidelines, keep track of the changes, because, you know, as everyone keeps saying, you know, this is a fast moving environment. To an extent, we are already making value judgments on things like, do we close sites? Do we keep them going? You know, how, if we keep them going, how does that work, taking into account safety issues? So, you know, value judgments, they're the kind of things that we're used to doing all the time. But what I would say is document them, not long documents, but just have it clearly set out so that in, you know, a month, 2 months, 6 months down the line, you know why you took certain decisions at certain times, particularly because we are in this fast moving environment. I think to an extent what we, in amongst all the guidance and the debate about to close or not to close, we possibly forget that there has been some legislation that's been issued. So we've got the Health Protection Coronavirus Regulations 2020, came into force on the 26th of March 2020, so shortly after Boris Johnson announced the kind of more severe lockdown that we're in at the moment. Because of the nature of the regulations, they're reviewed every 21 days. The next review will be on the 16th of April, which is why I say keep an eye on, you know, this fast-moving environment. Who, you know, to be frank, who knows what will happen, whether things might be tightened up or not. But at the moment, the regulations, and this is probably why it's causing a little bit of confusion, the regulations do not specifically say whether construction sites should close or should stay open. There's no definitive position on that. But what it does say is that people, and you can see the quote on that bottom bullet point, hopefully, people can travel to work for the purposes of work where it's not reasonably possible for that person to work from the place they are living, so from their home. I think we've all interpreted it very strictly, and it's very much being perceived as you've got to work from home or not at all. Well, that's not exactly what the legislation says. It is basically saying if you can work from home, then you should. You must, but clearly site workers can't work from home for obvious reasons. There's another provision that I haven't quoted, and it says that this 2-metre rule that we're all talking about, the 2-metre rule is to be implemented if viable. So again, it's not mandatory. If it's not possible to implement it at work, then there are it's not mandatory. Now, I think probably quite rightly for reputational reasons and for health and safety reasons, the construction industry tends to be implementing this legislation in a stricter way to that which it's drafted. But just bear that in mind, because of course we are seeing a lot from the government saying construction is to remain open. So, kind of coming back to the topic that we're going to be dealing with today, which is the financial implication of all of this and what you need to do to protect yourself. I think the first thing that I need to say before we start looking at these scenarios, we've got various scenarios happening. If you are today about to sign a contract or are negotiating a contract with a view to signing it, in the next few weeks, none of what I'm saying here today is necessarily going to apply. What you need to be doing in that instance is getting a bespoke clause into the contract to deal with this coronavirus situation and the possible inevitable delays and extra expense that it is going to cause. Now, hopefully it'll become apparent why you can't rely on the clauses that we're going to be looking at in that situation, but it's all to do with what you are aware of, the risks you're aware of when you're signing the contract. So, if what I'm talking about is a contract that you possibly signed 6 months ago, when clearly we didn't know there was a risk of coronavirus. Of course we didn't, because at the moment they're saying the earliest case of it looks as if it was November, December, so it wasn't 6 months ago. What we're looking at now is if you're signing a contract, you are clearly aware of a possibility that there may be delays, extra costs because of coronavirus. So this is why you need specific clauses in the contract dealing with the implications of it. So let's put that to one side, but please do not sign any contracts from now on without specifically addressing it. Okay, so the scenarios. As you probably expect, I've been talking to lots of clients, developers, contractors, subcontractors, and some consultants actually, about the implication of the virus, the government guidance, the government legislation, etc. And some key issues seem to be coming up. So these are the ones that I've come across. Apologies if you've come across others that don't quite fit in. Always interested to hear what other scenarios you're coming up against. So first one is government legislation closing sites. So obviously that is a possibility in the future. It has not happened yet. There is nothing in the legislation to say construction sites must close. The next two bullet points probably come together. So this is probably a scenario where site operatives get sick, or suppliers close, and therefore work on site sort of grinds to a standstill. And then the final scenario is one where the client closes the site. And in some instances, now I've got this on both sides of the fence. So I've got one where my developer client is querying why the contractor's gone off site in a situation where we think the work can be done very safely just because of the nature of it. It's outdoors work. We think that it can be done very safely, so we don't really think there's any reason for closing the site because of the virus. So we think there are possibly other reasons, and that needs investigating. We need to get to the bottom of it. And ditto on the other side, where sometimes clients are closing sites where there might not necessarily be a need, and there's nothing wrong there with actually, as I say, getting to the bottom of and investigating why that there has been the closure. Okay, so moving on to NEC entitlement and steps to take. So effectively, as we've already seen, we're looking at money and time. If you come to the breakfast seminars, you'll know that under NEC, really limited areas for claiming and being paid extra time and money. Acceleration is one, it's not relevant here. The other one, the main one, is through the compensation event process. So just as a recap, that covers your time and your money. So compensation events that we might be looking at, and as I say in all my seminars, with the beauty in a way of construction is that it's you're mixing both the law and the factual situation, and the factual situation, the scenario, is always very important. So what I always say is, if you're preparing to issue a compensation event, look down the list, just have a quick check through them and make sure you've claimed and notified of all the possible CEs, compensation events, that could apply. So I've looked for a selection. So the first one, the most obvious one, is prevention, which is CE 60.119. So it's number 19 in the list of CEs. And it's also dealt with in clause 19. It's basically a force majeure clause. There is some criteria to tick off, and obviously it's for the contractor, the claiming party, to tick off that criteria and show that it complies. So what's that criteria? Well, basically, it's got to be an event that stops the contractor completing the works. Well, that's not going to be the case here, but it also covers a situation that stops the contractor completing the works by the completion date in the accepted programme. So that's the element that contractors and subcontractors will be claiming under here. That's not the end of the story, though. There's more criteria. Contractor is also, claiming party, has also got to show that neither party could have prevented it. Well, the virus ticks that box. Also, that an experienced contractor at the contract date, so the date the contract has entered into, would have decided that it had such a small chance of occurring that it wasn't reasonable to factor it in. Come back to that one in a minute. And also it's not one of the other compensation events. So just going back to that, that reasonably known. That is why when we started this, I said, if you're about to enter into a contract now, you need extra clauses, because if you sign a contract now, you cannot say, I didn't reasonably think coronavirus would impact on my work. It's really just not going to wash. So this clause isn't going to help you, which is why you need that bespoke wording. You also need to consider when you did sign the contract. As I said, if you signed it 6 months ago, you're okay. If you signed it at Christmas, you're probably okay because we haven't heard of coronavirus. But then you're moving through, and at what point would it be reasonable to start to factor it in? Now, I can't give a definitive answer to that, and I suspect we might see some case law on that at some point in the future. But of course, case law in the future isn't going to help us today. So the aim here is just to get things lined up so that you're all in the best position possible. I think at the end of the day, there'll be arguments flowing from both sides if parties are going to get into a debate about this. But at the end of the day, I don't think anyone in this country was particularly worried about coronavirus until very recently. And of course, to an extent, we've seen the government sort of, having different strategies towards it. So, I think to an extent, the government weren't too concerned about it until fairly recently. So that's a hurdle that we're all going to have to cross at some point in the future, but just be aware of it. So that's the first one. The next one, change of law. Now, we haven't had a change of law as such yet to close sites, so I don't think you're going to be making claims under this. So that's, and note it's an X2 clause, so it's an optional clause. It may not be a part of your contract. Other possibilities, and these apply more where the client, so your client in the NEC contract, closes the site. So we've got the employer fails to allow access, so that's CE 60.1 brackets 2, and the project manager PM instructs work to stop, so that's CE 60.1 brackets 4. Probably 4's the best one to use if the site is closed by the client, because that is closing the site, whereas 2 is more aimed at deferring access to site. But I kind of take the view, if you're notifying compensation events, why not just put in as many as might be relevant? It doesn't do any harm. So they're the clauses that you might be relying upon as compensation events, and as we've seen, they get you time and money. Just to move on to termination. Now, I don't think anyone's going to want to be terminating contracts, but we need to consider it. Not least because the CE19, the prevention, says that if the suspension continues for for more than 13 weeks, so that's what NEC says, it may be amended to a different timescale, so you need to check that. So if the suspension continues beyond that, the employer, so not the contractor, only the employer, has the option to terminate the contract. So what happens in that instance with regard to the financials? Well, the employer pays the contractor's general costs, so the cost of work done to date, but it doesn't have to pay any profit or overhead for the work that hasn't been completed. So clearly that's not a great position for the contractor to be in. It's lost the work, the remainder of the work, and critically, it's lost the profit and overhead contribution. Now, I raise that because it means that if you raise CE number 19, there is a possibility that this will, result in a termination. And later on in the slides, I say one of the things that I think we should be doing immediately is talking to clients, seeing, how they see this going, because what we might find is that we get coronavirus sorted out, hopefully sooner rather than later, but who knows what's going to happen to the economy after that. And what we might see is a situation where clients are mothballing sites, as we saw 10, 12 years ago with the last recession. The other thing to note is that the employer can terminate the contract at will. So this is nothing to do with coronavirus. It's just a know-of point. So basically, nobody's done anything wrong. The client, the employer, just decides it doesn't want to proceed. Now, in that case, the contractor gets its costs plus it gets any profit and overhead that it would have earned had the work completed. So actually the contractor comes out, in theory, no worse off than had it completed the contract. Okay, so on NEC, steps to take now. Now, most of this, in fact, all of it, are things that you will be doing for every CE that you issue, I imagine. The first one, discuss and liaise with your client. I've already referred to that. Also, issue your early warning notice under clause 16.1. You may be discussing and liaising with your client, but still issue that early warning notice. It is an absolute requirement in the contract. And in fact, the requirement is that you give the early warning as soon as you become aware of a matter that could increase the price, delay completion, delay a key date, or impair the performance of the works on site. So it is immediate. I would hope that you've already issued your early warning notices. If you haven't, get them issued immediately. The next thing is notify your compensation event. Typically, you've got 8 weeks under a contract. Under a subcontract, I can never remember this, I think it's 7 weeks. Don't take my word for that. It's either 6 or 7 weeks. The thing that you need to be careful of, though, is that we see a whole raft of amendments to NEC contracts nowadays in the Z clauses, and that time limit is typically one that's reduced. Very often it's halved. And the same point actually with your compensation events. Quite often you'll find that a lot of the compensation events will be removed by amendment through the Z clauses. So before you notify any, just check that they're still in your contract. So notify your compensation event within the time limit, and then keep on to the project manager, make sure that they confirm the compensation event and request you to provide you a quote within the timescales. Check your service provisions in the contract. Normal NEC allows service by email on the parties in accordance with the details set out in the contract data. My view is with service, it's all about making sure that the other party knows what the issue is, that they've been told, that they've had the notification from you. So I take the view with things like this, it's really, really easy to email rafts of people. So if you've got lots of email addresses, I would put them all in within reason, not junior people who are just involved sporadically, but, if you've got high level people who you're communicating with, I would include them all. And also finally, general contract requirement, but specifically included in NEC, mitigate your losses. So, if people are coming off site, put them on furlough if it's appropriate, move people to alternative projects if that works, particularly if you've got urgent framework, utilities work, etc. to do. Take plant and machinery off hire if you can. You'll know other things that you're able to do. Okay, so moving on to JCT. I'm going to try and cover JCT fairly quickly. So in comparison with NEC, where we have compensation events where you must cover all your claims, so the cost, your delay and the cost of that delay, in JCT we have 3 separate provisions. We have variations for the cost of extra work. We have extensions of time, does what it says on the tin, extends the date for completion and avoids contract having to pay liquidated damages, or subcontractor general damages if general damages are payable. And we also have loss and expense to cover the cost of that extra time to the contractor or subcontractor. So looking first at that extra time, we're looking at relevant events. So they're a bit like compensation events, but they just cover time. What I've done is I've put the relevant clauses from the JCT Design and Build, the D&B contract. JCT is not quite as efficient as NEC, so the clause numbers are all different depending on which contract or which subcontract you're using. But what you will find is 2.26 is pretty much at the end of clause 2 of the D&B contract. So if you're looking on other contracts, you will find the relevant events right at the end of that clause 2. So what are the relevant events that apply? Well, we've got change in the law after the base date, which is pretty much the contract date. So very similar to NEC, option X2, except it is put in, it is in the contract, it's not an optional clause. We've got force majeure, nice bit of Latin, which obviously we don't have in NEC, no Latin in NEC. So what's force majeure? Well, it's pretty much that CE19. So it's basically prevention due to an irresistible force. So very, very similar criteria to that option 19. It's got to be something that neither party is responsible for, neither party could have prevented it, and that neither party could have foreseen it happening at the start of the contract. So again, I've already said this, if you're signing a contract today on JCT, you're not going to be able to claim force majeure for coronavirus, because obviously we know about it now. Be careful with force majeure because it's not defined in the JCT form of contract, but what will often happen is that in the bundle of amendments that we tend to get with JCT, there may be a definition in there. So if your JCT has that definition, you just need to make sure that a pandemic comes within it. It probably will. It will probably include an epidemic. So I think, therefore, we can assume pandemics included. The general consensus in the legal world is that coronavirus is a force majeure event. Just be careful again about amendments. I've already said NEC is going the same way as JCT with the rafts of amendments, and what we typically see with these relevant events is a lot of them being removed in the amendments. So be careful, check which ones have been removed. Don't be claiming a relevant event if it's been deleted from your contract. Also, what we quite often see in JCT amendments, this is the last bullet point in the slide, a clause that basically says if you've got concurrent delays, so one that is a relevant event, so one that could be force majeure, coronavirus, but one that is a contractor caused delay, then the contractor doesn't get an extension of time because it has caused a delay of its own. So just check out that clause. Now, what I would say there is, if that clause is in, I wouldn't stop that from I wouldn't let that stop you making a claim, because there might be arguments about what is the actual cause of the delay, where's the critical delay, etc. So please, don't not make a claim because of that, but just do be aware of it. it may cause problems once the claim is being investigated. So moving on, loss and expense. So this is you claiming your money for the delay. So for this, we've got relevant matters. Clause 4.221 in the design and build contract. Again, it's always towards the end of clause 4 in the JCT, but different clauses for different types of contract. Okay, now the bad news is that there's no loss and expense for a change in law and no loss and expense for force majeure events. So quite different here to NEC. And what you might actually find, what I'm seeing a lot of now in the NEC Z clauses is provisions where they say that if you have, for example, CE 19, what you will get is an extension of time, so you'll get more time, but you won't get money. So, you know, look out for that in NEC, mirroring that. Now, the logic here is that for these kind of events, you know, we know that it's not, you know, by the nature of them, by the very criteria of them, they are not things that either party has done wrong or could have prevented. They're sort of neutral events in terms of the blame game. And so that's how JCT deals with these. It's sort of a compromise. Contractor gets extension of time, but doesn't get any costs, any money. And similarly, client loses out because it can't claim any liquidated damages or general damages for delay. So that's just how the risk is shared under JCT. And as I say, you know, I've seen Z clauses mirroring that in NEC. Right, JCT suspension and termination. You know, we looked at this for NEC. So these are clauses 8.11, 12 for the design and build contract. So very similar. Sorry, step back a bit. If you have a force majeure event or a change in the law and the contract's suspended as a result, if that suspension continues for a certain period of time, then in JCT, either party can then give 7 days notice to terminate. So we saw with NEC, it was only the client who could do that, the employer. In this case, it's either party. In NEC, the time limit was 13 weeks. In JCT, the time limit, typically the default position is 2 months. And this is stated in the contract particulars. So if you've forgotten all your JCT, it's the bit that you fill in, the project specific information, and it's stated in the section 4 clause 8. So the default position is 2 months, but you need to check your contract at the back of the contract particulars to see if it's a different period. Typically it might be a bit longer. So you give 7 days notice, and so if you contractor gives 7 days notice, then the employer has those 7 days to either say, right, let the contract terminate, or say, right, well, we'll end the suspension and let's get going. Similar situation in terms of what the contractor will recover to that in NEC. So the contractor recovers the cost, everything that it's entitled to for the work carried out to date. It recovers its cost of demob, but it doesn't recover, it's not entitled to any losses caused by the termination, which is essentially the loss, the profit and the overhead contribution that it would have recovered for the remainder of the project for completing it. So very, very similar situation to NEC. And, you know, again, you've got to think about, you know, would either party want to terminate? I think it's unlikely a contractor would, because I don't think, you know, when we kind of get back to normal, hopefully soon, I don't think there's going to be a raft of construction work starting up You know, as I've said, you know, we might even be in a recession, things might be slow, but of course, you know, for the client, for the employer, it may suit them to terminate the contract on that basis. Service of notices. So we dealt with this in NEC. Again, it's different. Actually, it's not slight. It's very different in JCT. JCT's still, you know, slightly old-fashioned in this respect. Service of notices has to be delivery, so it's by hand delivery, which of course is tricky in this day and age. Recorded or special delivery. The good thing about it is that if you issue it recorded or special delivery, it is deemed to have been served on the other day, on the second business day after posting. So it's deemed, it's assumed to have been served. So that's service. Final bullet point, I've said email also to all. It's not a valid method of service, but do it anyway for the same reasons in NEC. You know, let's make it clear that, you know, we are trying to information, and particularly I think if you know, because, you know, our communication on a day-to-day basis is by email, I think it looks a little bit odd if you just post things. It's still valid service, but, you know, I could see an adjudicator not being happy if things haven't been emailed, because it might look a little bit like, you know, we've actually served it by post, hoping that no one actually picks it up, because who reads post? You know, we all deal with email. So, you know, that would be my advice. Extension of time notices. So with NEC, we have very stringent requirements for notification. We've got the early warning notice and penalties if you don't serve that. We've got a requirement to notify a compensation event within a specific time limit. And, you know, that is a condition precedent, because what it says is, if you miss that time limit, you're not going to get your time or your money for your compensation event. Not quite so stringent in JCT yet. What we've got up here is the extension of time notification, clause 2.24 of the design and build. So this is what the clause says. So what it says is, contractors got to notify the extension of time when the delay becomes reasonably apparent. So it has already become reasonably apparent. So hopefully, under your JCT, you've already notified. You've got to give that notice forthwith, so that's immediately. And in that notice, you have got to give particulars, so details of the expected effect of the delay and the estimate of the delay. Now, it is possible to send that information later, but, you know, my advice would be to try and give some indicator. Even if you're saying, you know, at the moment the lockdown is for, you know, another, I'm not even sure where we are with the lockdown at the moment, but we anticipate, you know, it will be extended. You know, there's lots in the news about it, so we can just put that in. Also, what you've got to remember, this final bullet point, is that if what the information that you give in that initial notice changes, you have got to update that and notify any further changes. And again, that's got to be forthwith. So that's what the contract says. What you need to be really, really careful of is standard amendment in JCT is to change all of that and make it a condition precedent. So quite often giving contractor, subcontractor 14, sometimes only even 7 days to notify, and specifically making it a condition precedent. So saying, if you don't notify within that 7 days, then no entitlement to an EOT. So please check those amendments. They'll be around about 2.24 in your D&B, probably earlier in your other contracts. Loss and expense, very much the same. So again, around about 4.20 in the D&B. The notice is pretty much the same. got to give the same information. Again, it's forthwith. But we've also got monthly updates for the loss and expense. So don't forget about that. And obviously, you know, it is going to increase monthly, the loss and expense. Sorry, I've forgotten to move the slide there. So that's the slide that I've just dealt with. Apologies. Right. So the next slide. So this is just to run through the scenarios that we're looking at. So you're leaving site for whatever reason, or things are slowing down on site. So this is typically, I think, you know, we've had problems with suppliers closing down and then opening up and not being able to supply, etc. And also, I guess, possibly having issues with sickness on site, possibly with people who have vulnerable health conditions, having to self-isolate. So if you are in that situation, issue your early warning notice. This is going to be a CE under number 19, which is the force majeure equivalent, and then, you know, issue your quote. Before that, of course, you should be getting from your project manager an acknowledgement that it is a CE and requesting the quote. So use your deeming provisions to force the project manager to respond if they don't. So I think the project manager has a week to respond. If they don't, you give them an extra notice, giving them another 14 days. And if they still don't respond, then it is deemed to be a compensation event and you can submit your quote. Don't forget what your quote needs to include. It needs to include the financial aspects of things, including your time, so prelims, etc. Also, it needs to factor in any extension of time to the completion date, and it's obviously going to require that in this case. Not all compensation events would, but this one will, which means that you must submit the programme updated to reflect that time. And rarely used, I think, but if there's going to be an extension of time, you're also going to be changing key dates, I suspect, if you have them in your contract. Right, so the next scenario, if you're instructed to leave site by client, or if you're a subcontractor by the contractor, I would leave your options open here, because this is a situation, well, you may be absolutely clear that this is because of the virus, so you may not want to leave your options open. If you're not, and I kind of referred to situations that I'm dealing with where we're not entirely sure that it is directly because of the coronavirus, then still issue your early warning notice, because it doesn't really matter which CE it is. If you were instructed to leave site or close the site down or suspend work, anything like that, then you need to issue an early warning, because it's going to change the costs, change completion date, etc. You also need to notify a compensation event, so you would probably use 19, as we've discussed. You might even use 2 and 4, which we've already looked at. You might even use 1, which is a change to the works information, if there is anything in there that is relevant and that would result in a change from the instruction. Just, you know, think about that as to whether that might be relevant. And then once you've got your notification back from your project manager, and again, if you don't, send the 2-week reminder, so the deeming provisions apply. At that point, issue your quote so that that can get sorted out. Okay, so on to JCT. If you're leaving site slowing down, I can fairly quickly deal with this. Notify your extension of time, force majeure, notify your loss and expense. Now, we know that you're not entitled to any here. So check your provisions, check there aren't any extra amendments that help you on this one. You might want to notify anyway, and see if you can negotiate some. And if the suspension continues beyond 2 months, or whatever the period is, I think before that you should be discussing with your client, trying to work out if there's a possibility that they're going to terminate. You may want to consider whether you would want to terminate. And if you're instructed to leave site under JCT, notify the EOT. You may want to couch this as impediment of the employer, which is a relevant event. Why you might want to do that is that if you notify a loss and expense, impediment by the employer, so the employer asking you to leave site, the employer stopping you doing work, the employer suspending your work, does get you your payment of your loss and expense. Now, I think what we're going to see are arguments there. If client is closing the site, they're going to be saying, well, we did it for coronavirus reasons, so it's force majeure. But we may see some arguments there, because at the end of the day, the government is saying at the moment effectively that sites can remain open. And this is, if that sounds a bit vague, what I would point out that this is unknown territory. I've been doing seminars for you guys for years now, and I've kind of tried to hone it down to key issues. And I must say, force majeure and these kind of clauses, I very, very quickly stopped talking about years and years ago, because, we just got to the stage where we thought, well, they never happen. So, this is, there are force majeure events through history, but, not like this. So, I think to an extent, what it's all about at the moment is keeping your options open. So another thing that you might want to do is notify a variation order under JCT, because clause 5.1.2 says that it's a variation if the employer restricts access, restricts working space, restricts hours or order of work, and a variation automatically entitles contractor or subcontractor to an extension of time and loss and expense. Right, so that's everything. Now, it must be a miracle, because this is probably the first time I've ever finished a seminar with 5 minutes to go. So 5 minutes for questions. So perhaps, Gemma, we should do these webinars all the time. Obviously, breakfast seminars, I just waffle on and on. So thank you for listening. Hopefully, I've no idea if anybody's actually been listening to this or not. Hopefully you've been able to hear. Hopefully it's been clear. Have we got any questions, Gemma?
Yeah, Sarah, can you hear me? Sarah?
Hello?
Hello, Sarah.
Hello. Could you hear me?
I could hear you, yes. Apologies. So I'm not sure if you're able to see the questions on your screen, but they should have popped up now for people on the presentation. Is it easier if I read them out to you?
Yeah, and then if people haven't got the screens open, they can hear the question as well.
Excellent. So we've had one. What if clause 19 and X2 have been deleted from the contract and you intend to slow down works or leave site?
Right. you're going to have to find some other clauses to claim under within the compensation event mechanism. So you're probably going to struggle, because effectively the way the contract has been set up and negotiated, and I appreciate it probably hasn't in reality been negotiated, but it's been done on the basis that contractor takes the risk of those events. So I think you're probably going to struggle unless you can find something in the works information that helps you to claim under number 1.
Okay. The next question that's come up should be coming up now. What happens when no notification is given by either party but a claim is raised later?
Okay, well, the 2 issues, I'm assuming that we're talking about NEC contract. If the contractor fails to notify the compensation event within the 8 weeks or whatever the time period is, then if it is a compensation event for which that contractor is required to notify, then you cannot raise the claim later on down the line if you miss that deadline. You've got to still carry out the works, but you're not entitled to any extra time or money. Really harsh, I know, but you've got to comply with those time limits. Now, having said that, if you realise you've missed a deadline, I wouldn't necessarily just just accept that you're not going to, there's no wriggle room there. If you realise you've missed a deadline, I would still notify, still set the process in train, and still submit quotes and quantify the claim, because quite often there is wriggle room. So, my job's sort of split into 2 halves. One part is saying, as I've been doing in this seminar, what you should be doing now to protect yourself for the future. But this is kind of very much, what I'm saying is this is in a perfect world, and it is quite common for these time limits to be missed. Sometimes there are arguments, there's wriggle room, which is why I say don't just think, right, we've lost that, that's the end. Still submit it, and it might be that there is wriggle room. Quite often clients will take the view that even though the time limit's been missed, it's not impacted on anything, so they will still look at the claim. But really we should be complying with that time limit. With the early warning notice, the obligation there is on both parties actually to issue an early warning notice, so the contractor and project manager. So I think there's maybe a little more wriggle room, particularly on a topic like this, if neither party has notified, because this isn't something that only contractors have known about. Having said that, the implication for the employer, it's not stated in the contract, although it is a breach of contract. So technically, contractor could issue a compensation event for breach, which is CE18. But as far as the contractor is concerned, how the employer is entitled to value that compensation event, which relates to the early warning notice, is they value it on the basis that the early warning notice had been issued. So if they can say, well, we could have done X, Y, and Z, and that would have reduced the implication of this, that they value it on the basis of their mitigation measures. Now, I kind of struggle to see how employers could have mitigated it. I think one thing there might be an issue about is this issue of suppliers, closing down, and there might be arguments about, well, come on, we could see this lockdown coming, we've seen what's happened in, across Europe. So, what we should have been doing was getting all supplies delivered to sites so the work could carry on. So, this is the difference between, you know, arguing the perfect world now, what we need to be doing now, and, you know, when, you know, we get to usually, you know, later on down the line arguing what's going to be paid and what isn't, you know, trying to find some wriggle room, because at the end of the day, these timescales, you know, they're harsh. To not get paid and not get extra time because of a lack of a notice, you know, it is harsh. But, you know, as I say, you know, if you can comply with them, so, you know, you can now, so please do comply.
Excellent. Sarah, just looking at, we've got a few additional questions coming up. I'm just a bit wary that some people may need to get off and obviously have other meetings and conference calls. Sarah, are you happy to answer a couple more questions?
Yeah, sure. I mean, I'm happy to just continue, and I guess people just disappear off. I mean, what I do normally say to Seeker members is, you know, my email address is on the slide, so if you think of queries later on, you know, drop me an email.
Well, if we're happy to go through these
we had a bank holiday this weekend,
yes.
So, you know, I'll probably be the sad person who's, you know, up and at my desk on Friday morning. So
if you're happy to go through a couple more of the questions, I'm happy to do that.
Absolutely.
If I could just ask, just before, if anybody does need to get off, I'd just like to say a thank you. I know Mark, our director for Seeker Yorkshire and Humberside, wanted to thank Schulmans and Sarah particularly for today's presentation and for helping us out and helping us to continue to support members at this time. What I'd ask then, just before we do a little bit more of a question and answer session, for the people that are on, if they could just take a minute out of their time to just do a little bit of feedback. There should be 4 questions that should just pop up onto your screen now. 4 questions maybe? Yeah. So if you could just take a minute and answer these, and then once everyone's popped those through, the last one just asks for any topics that you'd like to see covered. Again, don't feel like you have to put something in there. If you do want to email us or contact us afterwards, that's absolutely fine. But if you could just let us know, that'd be good. And then we can just go through these additional questions that we've got coming up. Thank you. Just while people are doing that, I'll read out one of the comments that someone has put on here. Someone stated that on JCT, the force majeure has been amended to any other occurrence or amounting to a force majeure. Sarah?
That's right. That suggests to me, particularly, I'm looking at this one actually, and particularly because where it says amounting to a force majeure, and that's capital F and capital M, that suggests to me that somewhere else in the contract, force majeure is defined. So I think you'll probably find in the definitions that force majeure is more specifically defined. I'm sorry, that's all I can say on that one.
Okay. Another comment we've had is there will inevitably be demobilisation and remobilisation associated with the pandemic. Is there a mechanism for dealing with this under the NEC forms?
Yeah, that would be part of your quote for the compensation event, and it will be covered in the schedule of cost components. So you would do your normal quote, you know, go through that, what I think is that horrendous list in the schedule of cost components, and the mob and demob will either, I think it'll probably be covered. it's going to be a mixture, I think, of your staff, your people costs, so the first item, and the second one, your plant and equipment. There might be a few charges items. So it should all come within that.
Okay.
So yeah, I think that covers that.
Fab, thank you. I'll just end the voting on there and then go back onto the question part. So we had a question here. What happens when there isn't an accepted programme, i.e. entitlement, under clause 60.119? Demonstration that the contractor could not complete the works would be subjective unless a complete date is imminent.
Yeah, perennial problem, because, and it's a problem with all compensation events. If you haven't got an accepted programme, and this is why you need an accepted programme on NEC, because it's all about dealing with it today, not 6 months down the line, as tends to be the case with JCT. So yes, you do have an issue in that you don't have the accepted programme is the programme that applies today, so it represents what's happening on site now. So it means that you've got a compensation event, you've got a claim for delay, and you can impact that onto today's programme to show what effect it has. If you don't have that, then your hands are tied slightly. I think you've got to, that technical term, I think you've just got to cobble something together, because this is a problem, but you need to submit a programme, I think, because at the end of the day, what I'm interested in, and we're always, I know this isn't how you guys look at things, but the end game here that we're all looking at is making sure that if you are absolutely forced to adjudicate this, you've done everything you possibly can, that you've done all the right things. So the idea is you put in a programme. What I would say, put in the programme that you think applies, even though there isn't an accepted one, and clearly shows that delay. And basically all it is a record today as to what you're saying is the position, because in 6 months' time, if you're thinking about, pursuing this further, if you've got that programme, you've got a record. If you haven't got it, you've got no record, and it's really difficult to show. So that's a sort of practical response to a failure by, it might be both parties, it might be one or the other party, to have this accepted programme, which is quite common.
Okay, thank you. We've had one here. When talking about the health protection regulations, you mentioned working to a 2-metre rule if viable to do so. Where in the regulations is this covered? Hello?
Right, I can't hear Gemma now. So
can you hear me?
I've got that question, so I'm going to repeat it. I'm hoping I'm not speaking to myself. So the health protection regulations, I mentioned working the 2-metre rule if viable. Where exactly in the regulations is this covered? Drop me an email. Oh, that's from Neil. Drop me an email and I'll try to find it. I haven't got a note of it, and it wasn't on the slide. It was something that I raised with a client, and I haven't kept a record of the provision, which is naughty of me. So apologies for that. Drop me an email, and I'll see if I can find it. But you might want to have a rummage around in the regulations yourself. It's only about 800 pages. Are you there, Gemma?
Okay. I'm trying to be here. I may have disappeared.
Yeah,
I'm not sure. You can hear me now?
Yeah.
Excellent. What happens when utility companies refuse to undertake non-essential diversionary works because of COVID-19 issues, but this disrupts or closes planned contractual works?
Right, I'm going to read that one out again because it was a bit jumpy. So what happens where utility companies refuse to undertake non-essential diversionary works because of COVID-19 issues, but this disrupts closed planned contractual works. I think that's probably a very fact-specific issue, and it sort of depends on whether, you know, all the work is within one framework, whether it's moving a contractor around on projects within a framework, or one contractor's being told to stop work so another contractor can do work. So I'm really sorry, I can't, it's just too much of a general question to deal with. I mean, it seems to me that if a contractor is able to do both, or is still able to do its non-essential work, it really depends. If the contract is, if the contract is part way through the non-essential work and they stop it or suspend it, then it is exactly this scenario that we've been looking at today. If it's something different where they're saying to the contractor, move on to essential work instead, it's probably slightly different, because of course, whilst you might want an extension of time on the initial project, there's not going to be much loss and expense. I wouldn't have thought there aren't going to be much losses because the contract has been moved on to another project. Now, that's not to say there won't be any, but you might have to take that into account. I hope that helps. Okay, Gemma.
Okay, I'm just publishing another one online now. Can you hear me? NEC, how is the second bullet point of 60.119 satisfied? It's quite a complicated question. Is it as simple as showing a scenario of 1 month delay due to inability to work within social distancing guidelines, and therefore the contract will be finished 1 month later than the date shown? Or does the option of acceleration, mitigation, or rescheduling need to be considered before the threshold can be reached?
Right, I've lost you, Gemma. Can you hear me?
Yes.
Right, I'm going to read that question out. So this is about the second bullet point of clause 60.119. So where an experienced contractor at the start of the contract, the date of the contract, would have thought, right, coronavirus has got such a small chance of occurring that it's unreasonable for me to factor it into the price. So how is that satisfied? First thing is, it's not a case where I can say, right, if you do this, this, and this, you've satisfied it. If you do something else, you haven't. There are some things I could say definitely, don't satisfy it. So my point about, if you're entering into a contract today, you're definitely not going to be able to use that clause. A lot of it is judgment, and, the facts of the case will be relevant. So the question goes on to say, is it as simple as showing a scenario of 1 month delay due to inability to work? Well, and I think we're going to have different issues on this potentially. Or does the options of acceleration, mitigation, or rescheduling need to be considered by both before the threshold can be reached? No, I don't think any of those issues need to be considered. In terms of inability to work with regard to social distancing, I think that is a good question, because the issue is, what exactly do you have to have factored into the contract? Are we talking about factoring in a pandemic? And I think the date for factoring in a pandemic, if that is the issue, was probably, at the very latest, earlier on in March. It could be earlier, but I think that would be quite harsh for contractors. But if the event that stops you completing the works is people being sick, then can we say, well, actually, this is about people starting to be sick rather than coronavirus itself? And I think that raises an interesting issue about the factual scenario. And I don't think there are any answers to that. As you'll probably all know, there's little case law on any, and there's definitely no case law on this. Inevitably, there will be case law on it in the next 12 months. So this is one area where, we're just going to have to wait and see. But, our job at the moment, your job at the moment, is to think about the options and just try to make sure you get in as quickly as possible with these claims. And to an extent, if Clause 19 is the only one you can claim under, you've not got much choice anyway. You're just going to have to argue it at some point later on down the line.
Okay, Sarah, can you hear me now at all? Because I think that would probably be the end of the presentation. I think we're done with questions for now. So I think that's everything that we've been through. If anyone does have any additional questions that they would like Sarah to have a look at, if you want to obviously email Sarah directly, or feel free to contact Seeker to contact me. You should all have my email address through the webinar booking. And if anyone also would like a PDF of the slides to go alongside this webinar, please drop me a line and I will sort them to you. Thank you very much for everyone attending today. I hope that's been useful. And thank you very much to Sarah once again for excellent delivery through this new medium for us. I would like to wish you all well. Enjoy as much as you can the bank holiday weekend coming up, and stay safe, everyone. We hope to see you at our next webinar. Keep an eye out for our next invitations. Thank you very much.